Hi everyone, I welcome you to our NLTI series where we are walking you through some basic NLSAT related concepts. Today's session is one of the most important ones. It's about using principles in part B. Now, many of you if you're just starting to do your prep for NLSAT and if you've gone around scanning some online sources to help you prepare for this paper, I'm sure that there is a constant doubt in your mind about what to really write when it comes to answers in part B, and what is it that makes a difference between a person who clears the paper or perhaps anyone who gets good marks for an answer in part B and someone who doesn't fetch as many marks. There is also a constant doubt that do I really need to mug up legal principles or legal maxims? As you can observe, this slide only says using principles, it does not use the word legal. And that's a very conscious choice because as someone who's been through this paper myself and have mentored students over the last 3 years, using legal knowledge or the expectation of having prior legal knowledge is absolutely unnecessary. So if you're wasting your time reading about principles of tort law, contract law and everything, or concepts of tort law, maybe contract law or even criminal law, it's really not that important. You need not waste your time mugging up those concepts. I'll give you a very simple reason why you shouldn't do that. The first reason is those legal concepts, first of all, are explicitly not expected in this paper. If you read the instructions provided by the team which conducts NLSAT, they never ask you to have any prior knowledge of law. In fact, they tell you to not, or they do not expect any such knowledge. Second is, most students tend to apply legal concepts wrongly. Now, keep in mind, part B is a subjective component. It's not like it's a part A where you have to tick among 4 options and one is objectively the right option. In part B, however, you're supposed to explain concepts, you're supposed to use reasoning to explain those concepts in your answers. Many a times, most students who learn about these legal concepts through any source end up using them wrongly because you only understand some bits of it. These concepts are way more complex than they appear when you read them online from some source. So the only thing you're really expected to do is apply basic principles in part B. Now, what you're permitted to do is if you come across a legal concept, every legal concept rests upon some basic principles. What NLSAT expects out of you is how you use those basic principles upon which any legal concept rests. They are not looking at how well do you know that legal concept. That by itself will not fetch you marks, but how good your grasp is of the basic principles which are beneath that legal concept or which form the basis of that legal concept is more important. So for example, if you are not able to explain a certain legal maxim, for example a maxim like volunti non fit injuria, it's completely okay so long as you know the idea behind it and how that concept works through principles. So this session I'm going to walk you through some basic principles. The objective here is that in case you're not sure about what principles to use and if you need some initial kickstart energy, then this is a good session to just give you a hang of what different principles are involved in different scenarios. And then you can expand upon those principles in your answers to frame quite convincing answers. Now, the first type of, I'm only going to talk about a few types of questions which have occurred quite frequently in the paper. One among those questions are questions involving harm to someone. These are questions where somebody either physically injured another person or even non-physically injured another person through indirect actions. So these are the sort of questions in which basically anybody who faces any harm, the key operative word is harm, then in those cases these principles are relevant and you should assess and you should look at which of these principles you could use in those cases. And these principles will start first with due diligence. So let's say I was trying to board a bus. We'll use this example so that we can easily understand these principles. I'm trying to board a bus and I'm in a hurry. I have a job interview and this is the last bus which is going to go from this particular bus stop. While the bus was just about to take off and I had to run to catch this bus, and while doing so I accidentally pushed another person. I did not intend to do so, but it just so happened that I pushed another person, and that person, because of my push, fell off the bus and sustained some injuries. Now the person says that I have suffered a harm and I will therefore sue this person for damages or for compensation, that you should compensate me because you have physically injured me. So now the first thing you'll ask is that the person who boarded the bus here, because of whom the another person fell, did they exercise due diligence? By due diligence, we mean how much caution one must exercise. Every action we take should have some degree of due diligence, which is that are we cautiously taking an action, which also flows into the concept of duty of care. But basically, the due diligence is that take adequate precautions before taking an action. And if you've taken adequate precautions, then you can say that, well, I was trying to board the bus. This other person was probably hanging by a handle on the bus, so it's not my fault that they got pushed off the bus. But I, in my own right, took every measure that I could have to ensure that someone else does not get harmed. So due diligence is important to show that I took adequate precautions, and if anything else happened beyond it, it's not my responsibility. So you should look out for things like due diligence in that respect. Second is duty of care. It means that, in very simple words, duty of care, although is used like a tort law idea, but I want you to use it as a very basic principle, which is that, do I owe something to someone? So if I'm somebody who's trying to board a bus, do I have a duty of care to another person? You could say that I have that duty of care because all of us are passengers on that bus and we owe some degree of safety to one another. We need to ensure that two people do not push each other off the bus or do not cause any injury to one another. So therefore, there is a duty of care to ensure that we do not cause any harm to the other person. How much though? That's a different thing. How much duty of care do I owe? If I'm trying to board a bus running with very little time on my hands and in my capacity, I did my best to not injure someone else, then can I say that the duty of care is so big that you should make sure that absolutely no one is harmed by your actions? So how and how much of this exists is something you'll have to answer based on how the question is asking you to judge that situation. But it's a relevant thing to have in your mind that, do I have a duty of care? Do I owe something to this person who has been pushed off the bus? To give you another simple illustration, in this case, it's another person who has boarded the bus, so I'll have to check whether or not I have a duty of care. Let's say it was some other passing by passenger. They were not boarding the bus, but they were just simply standing somewhere, and as I was trying to board the bus, I accidentally pushed them off. In that case, you could say that this person was not even a passenger on the bus, had nothing to do with me, so maybe I don't have that duty of care to them. So this concept of duty of care can vary depending on whom we are attaching it to. Reasonable mitigation of harm. This means that once the harm has been done or is about to be done, are you trying to mitigate the extent of the harm? So in many cases, this could be used wherein, let's say, some industry is operating on the river banks. For example, it's, let's say, a glass manufacturing industry which is operating on the banks of a river, and this industry is routinely releasing sewage material into the river. Now, what we are supposed to now here check is that, is this industry taking reasonable steps to ensure that as little sewage is released into river as possible, or are they just simply dumping every single piece of waste material into the river? So reasonable mitigation of harm means that when you're committing or you've already committed the harm, are you taking adequate steps to mitigate the extent of the harm? Because that shows that you actually have the will to not commit excessive harm on someone. So that's why the concept of reasonable mitigation of harms is important if you're trying to defend someone who has committed any harm. Third is unavoidable harm or foreseeability. Both are very different concepts. Unavoidable means I could not have prevented this. So for example, in this case, this person who is boarding the bus, imagine this person was actually instead of boarding the bus, this person actually saw someone who was about to fall from the bus. Maybe it's a small children, it's a 10-year-old child he sees who's hanging by a door handle on the bus, and he thinks this child can fall. So he runs to save that child, and on that way, he accidentally pushes someone and that person sustains injury. So then you can say that it was unavoidable. I was trying to save someone else, and therefore my action caused harm to another person. So therefore this harm was unavoidable, because how else do you expect me to not react when I see someone else, or especially a small child who I think was about to fall from a bus? So I had to take the best course, and in that I accidentally pushed this person. So therefore that harm was unavoidable. So you can use this again as a defense in case you're defending an individual who has committed the harm. The third one, or the part of this, is foreseeability. You can star mark this also because it's a very frequently occurring concept. Could you have foreseen this? So for example, if I could foresee that if I'm running towards a bus and if I push someone as I'm trying to board the bus, then can you foresee that harm? Many of you would say that if it were a crowded bus station, then yes, it's foreseeable. If you're running headlessly without paying attention to your surroundings and then you push someone, then yes, it is foreseeable what you did. So in those situations, you can say that the risk that you or your actions were foreseeable. And if my actions are foreseeable, then I should be held responsible for the consequences of my actions. So basically, if I knew what I'm doing, and I nonetheless do that thing and it causes harm, then I'm responsible for it. So you should see that if or not the consequences of my actions are foreseeable, because sometimes they are not. Maybe for example, when this person was trying to save that child from the bus who apparently was falling and then pushed someone accidentally, then you can say it's not foreseeable. I could not have possibly anticipated that I'll push someone on the way when I'm trying to save a child. So in those cases, you can say foreseeability. If you have to take this glass manufacturing example, in this case, maybe foreseeability does not apply, because if you're an industry who's dumping waste in a river, you know the harms that it will cause to the river. You'll know that it will cause more pollution in the river. It will cause adverse effects to the ecology of that surrounding. So that's why you can say that in that case, you cannot raise the defense of foreseeability because you could actually foresee the harm you're committing. So depending on the situation, you can use foreseeability as well as quite useful. Interests of the common public, this is mostly to just show that in some cases, the harm you have done, does it also impact other people? So mostly the harm is limited to two parties. Let's say A harmed B. So we only assess between A and B how to distribute liability. But sometimes it goes beyond just B. Maybe the actions of A had an effect on other people as well. So in this case of glass manufacturing industry, which is dumping waste in river, you can say that the interests of the common public are also at stake, because by dumping waste, they're causing harm not just to, let's say, a surrounding village, which has, let's say, 100 people who depend on this water. They're also affecting all the people who will be taking water from this river, which feeds into multiple rivers. So that way you can say that the interests of common public are also important. Use this when you feel that the effects of harms are more than just limited to the two parties who are involved. The third and the last one is contributory negligence. Again, I have worded this in its legalistic tone, but in very simple words, it means is that if I have committed harm to another person, has that person also contributed themselves to that harm? In simple words, for example, let's say I'm driving on the wrong side of the road and then someone comes and rams their car into my car. So then I'll say that, oh, I have sustained harm, give me compensation. The other person will say, well, you were driving on the wrong side of the road. How is it my fault? So then you can, if you're trying to defend one side, you can say that it's contributory negligence, that the other party was also responsible. They also contributed to the harm. If this person was not driving on the wrong side of the road, this accident would not have happened. Similarly, you can also say that just because I was driving on the wrong side of the road does not mean the other person can rashly come and ram into my vehicle and cause injuries. So you can also go against it by using any of these concepts like, was this person driving excessively harsh? Was the other party driving in a way without taking any due diligence, without factoring into any caution, all those kind of things. So all these are concepts that you can use quite handy when there is a situation which involves harm to someone. Quickly, when a contract is involved. Now this is also quite important, because in some situations, whenever a contract is being formed between any two parties, A and B, or more than two parties as well, we have to look at a few things in that contract. The first is capacity. In simple words, it means that the parties who have entered into that contract, are they actually capable of entering into that contract? It becomes important, for example, two parties, I am a young artist, I have entered into a contract with a big music company. Knowing that I'm a young artist, that big music company gives me, let's say, 2,000 rupees a month in return for me singing for them and recording some music videos for them. And this contract binds me to only be given 2,000 rupees irrespective of how much sales that music company makes by using my videos. So if in the later date, it turns out that this music company is making lakhs of money by my work, but they only pay me 2,000 rupees, in such a case, you could say that this contract seems very unfair. So capacity basically deals with the aspect of were the people who are into contract capable of contract. So let's say if it's a children, you would say that a children is not capable, they're young, they're impressionable. Similarly, if someone is too old, they're capable of entering into a contract, but they will not be actually in a contract if it's someone who's 80-year-old person, or somebody who's medically sick, somebody who is not conscious when they're entering into a contract. Let's say I am drunk when I got into a contract with someone. I promise that I'll sell you my car for this and this much amount of money. You would say that because this person was drunk, so they were not capable of entering into contract. So when you're assessing any contract and its validity, look at whether or not the person was capable. Second is consent. Not just consent, but it should be informed and full consent. These two words are important because one should know what they're consenting to. Sometimes your consent can be clouded by terms that you're not familiar with. So this example of artist is very relevant here. Artist did not exactly knew the extent to which their work could be used by the music company at a later stage. So you could say that while this artist consented to only take 2,000 rupees, but if you really look at it, this person did not know the extent to which their work could be marketed. So that's why their consent was not full and informed. In some cases, for example, I'll tell you that I'll sell you my car, okay? My car is a brand new Honda City and I'll give it to you for, let's say, 10 lakh rupees. I sold this car to the other person and the other person comes to find out that this car actually has a lot of internal defects which I was not told about. So then you can say that my consent was not there because it was not informed. I did not even know about the features of this car. I did not know about all the problems that this car had. So therefore my consent cannot be informed. Informed basically means the person should have as much information as possible before giving a consent. So just because I've given the consent is not enough. That consent should be based on as much information as possible. So in contract cases, always keep in mind that your consent should be informed and full. Intention to be bound by a contract. Again, if I'm drunk and I get into a contract, I might have even signed a contract, but did I have an intention? Intention is important because you must actually be willing to get into a contract. Take another example. Maybe for example, my father pays me 10,000 rupees every month as a pocket money. Now, after 6 months of paying me this pocket money, once I get into college, post 6 months, I ask my father to pay me 10,000, but my father tells me I cannot pay you money this month because of some emergency. Can I now sue my dad to pay me 10,000 rupees? And probably not, because even though he was paying me a regular sum of money month after month and he promised me that I'll pay you 10,000 rupees every month, he probably was not intending to make it a contract. He was never intending that this will take the shape of a contract. So it's very important to gauge whether or not parties are actually intending to come into a contract. This is also important. Was a contract too vague, harsh and valid? So in the case of an artist, if you think about it, if an artist is recording music videos for a company every single month, let's say the artist records the music, let's say records 5 to 6 music videos in a month and the company only pays him 2,000 rupees, we can all infer that this is a very harsh contract and no one should be subject to that. So irrespective of all these conditions, if a contract is too harsh and it's too excessively harsh on one party, then we can say that it's not a valid contract. Or if a contract is very vague in its terms and does not really specify the exact obligations on the parties, so you can say that it's too vague. Again, the contract should be free from coercion, that parties when they get into the contract should not be in a position where they're coerced into it. So for example, let's say if this artist was financially struggling and had a very difficult time and this music company says we'll pay you 2,000 rupees, you agree to sell all your music catalog to us. You can say that this artist was probably not free from coercion because due to my poor financial condition, I entered into this contract and it was not my whole intention to come into one, but due to the circumstances such that I went into this contract. So you can say that in this case, the contract was not free from coercion. Lastly, again, fairness, to ensure that any person who comes into contract is treated fairly. It shouldn't be the case that one party treats other party unfairly. Just because they're in a contract does not mean you have a right to treat someone unfairly. Then there is a concept such as good faith, to ensure that all parties treat one another in good faith. For example, if one person is in a contract with another person, there is an unsaid obligation on each other to display good faith. So let's say that in this example where one person sold Honda City to another person but did not tell them that this Honda City has a lot of internal defects, then you can say that it's out of good faith that one party should reveal such information. Maybe not in all cases a party can expect to know about internal defects, because you can check the outside of the car but not how exactly it is functioning. So it's through good faith you can expect one party to disclose such material information about their car. When you're assessing the validity of any action, then in those cases these things become very important. Any action, this could be an action taken by an individual or by any other person, then in those cases you should look at these things. So procedural fairness is important, which means proper steps should have been followed. What I mean by this is that, let's say for example, a teacher has been suspended from school. The teacher was suspended because a lot of students wrote to the principal that this teacher is not teaching well and they have a lot of concerns about the quality of their teaching. As a result, the principal wrote a letter to the teacher that you're immediately suspended. So now you're supposed to judge whether or not the principal's actions are valid. So you will look at, the first thing is that whether or not the action was procedurally fair. And what will you look at in that? First is, was proper procedure followed? Was the teacher informed as to why they are being suspended? So they should be first told what is happening to you and why is it happening to you. Told how though? So there should be a proper mechanism to inform them. So maybe a notice should be sent to them. Second, they should be heard. I mean, if I'm being suspended because I'm not teaching properly, I should also be given a chance to explain my side of the things. Maybe it was only on a few days that the teacher did not teach properly, or maybe because the teacher was dealing with some other emergency which caused them to not teach properly. So then that person should also be heard as to why. So before any action is taken against me, I should have a right to explain my side of the things as well. Thirdly, the steps taken should be adequate, which is to say that if I have not taught properly, taking a step like suspending me seems too harsh. Instead, if I were given a warning by the principal that I have received a so and so complaint and I would expect you to increase or perhaps improve the quality of your teaching, then that's something which you would call as an appropriate action. Instead, if I'm straight away suspended without any inquiry done on me, then that seems an excessively harsh action. So that's why the steps which should be taken should be actually adequate. There shouldn't be excessively harsh steps on that person. Then there are things like transparency. Transparency basically is also part of procedural fairness. For example, in this case, if the teacher is not told as to why they are being suspended, you can say that such action lacks transparency. Appearance of impropriety. Even if the action is actually valid, let's say the principal suspended the teacher, told the teacher, we are suspending you because we believe that your teaching quality has not been up to the standards of our educational institution. But this decision as was being made by principal, the principal also had some past relationship with this teacher wherein they were both involved in some fight. So the principal passed this action. So now you can say that maybe the principal had their own vested interest. So then you will expect that this principal to take this action in consultation with more people. So action should also appear to be procedurally unfair. It's not just enough that your actions are actually procedurally fair. There should also be an appearance of fairness. So if there is any appearance of impropriety, irrespective of whether there is actual impropriety, even if there is an appearance of impropriety, even that makes our action liable to be considered as a suspicious action. So that's why even this is important. So whenever you are assessing the validity of anyone's action, always keep in mind these three things. They'll be very important and very helpful for you in writing answers. Lastly, quickly, you can also use concepts like reasonable reliance and assumption of risk. These mean that, for example, let's say I have an exam to give and I have asked a friend to help me or to take me to that exam center in the morning. The friend says, well, I'll do that for you. I told them that you should come to pick me up at 7 a.m. The friend did not show up. And as a result, I missed my exam. So now I'll go and ask for compensation for my friend because, well, I had asked you to actually show up on the set time. And even, let's say, even if it's not a friend, I booked a Ola cab instead of a friend. And the Ola cab did not show up. So if I now wanted to ask compensation from Ola, the way I can ask is through the concept of reasonable reliance, that I relied upon your services, and due to the failure of your services, I was not able to attempt an exam. So even though there was no contract as such, if I book a cab and it does not show up, it's just how things happen sometimes. But if I wanted to take an action against them, I can use the concept of reasonable reliance. Whenever you rely upon any person to perform an action and that person fails to live up to that reliance, then you can ask for compensation from those people. Similarly, in the same example, you can use the concept of assumption of risk also. Some action by nature assume a little bit of risk. So when those actions fail, or if you are trying to sue or trying to bring a claim against someone due to their lack of action, then they can hold a defense of assumption of risk. If I'm booking a cab, I know that there's a good chance the cab might be cancelled. So I assumed this risk that when I booked a cab and I did not have any other alternate contingency measures, then I have somewhat accepted the risk, because it's very well known that these cabs are not 100% guarantee that they'll show up. So that's why the concept of assumption of risk also becomes important when you're deciding whether or not someone is responsible. So this was a very quick preview of all, or at least some of the most important basic concepts you should have in mind when you're going through any question or going through specific types of questions. So I hope this was helpful for you. This is all we have in this session. So thank you for watching, and I hope this helps you in writing better answers and come with better principles. Thank you once again, and we'll see you in other sessions.